Imagine someone you've never met is on a wiretapped phone call talking about a drug deal, and they mention your name. You weren't on that call, you didn't know about it, and you may not even know the person who said your name. But under federal law, that recording can be played for a jury as evidence against you, and you never get a chance to cross-examine the person who said it. That's co-conspirator hearsay, and it is one of the most powerful tools federal prosecutors have in drug conspiracy cases. Under Federal Rule of Evidence 801 D2E, the government can take out-of-court statements made by an alleged co-conspirator and use them against every other member of the conspiracy at trial. We're talking about wiretapped phone calls, text messages, and recorded conversations you were never a part of. I'm Michael Lowe, criminal defense attorney here in Dallas, Texas. I've been handling federal drug conspiracy cases for over 25 years, and I'm going to break down exactly how this rule works, what the government has to prove before these statements come in, and most importantly, how to fight back against it. So normally hearsay, which is an out-of-court statement offered to prove the truth of what is said, is not admissible in court. That's a basic rule of evidence. The reason is simple. If someone said something outside of court, the other side doesn't get a chance to cross-examine them about it. There's no oath, no ability to test whether the person was telling the truth. Federal Rule of Evidence 801 D2E creates a carve-out for statements made by co-conspirators. And here's the interesting part. The rule doesn't even call these statements a hearsay exception. It classifies them as not hearsay at all. That's a legal distinction, but it has real consequences because it means the usual protections against unreliable out-of-court statements are treated as if they don't apply. In a federal drug case, this is how it plays out. The DEA or FBI gets a wiretap on someone's phone. They record a call where that person is talking about a drug transaction. And during that call, they mention your name. Maybe they say you're involved. Maybe they use a nickname the government later attributes to you. You weren't on that call. You didn't know about it. You may not even know the person who was talking. But under this rule, the prosecution can play that recording for the jury and argue it proves you are part of the conspiracy. Now, before these statements can come in, the government has to establish three things, and the judge makes this determination before the jury ever hears the evidence. First, the prosecution has to show that a conspiracy existed. Under federal law, a conspiracy is a simple agreement between two or more people to commit a crime. They don't need a written contract. They don't even need to show the conspiracy succeeded. Circumstantial evidence like phone records, surveillance, financial transactions, and testimony from cooperating witnesses is usually enough. Second, the government has to prove that both the person who made the statement and the defendant were members of that conspiracy. It's not enough to show you knew somebody who was involved in drug activity. They have to show you actually agreed to participate. Third, and this is where a lot of the battles happen at trial, the statement has to have been made during the course and in furtherance of the conspiracy. That means the statement had to have been made to advance the conspiracy's goals. Conversations about setting up deals, discussing prices, and arranging transportation all qualify. But someone bragging about past drug deals to a friend or making a confession after the conspiracy is over, those generally do not qualify. Now, there's a Supreme Court case from 1987 that made all of this significantly easier for prosecutors. It's called Bourjaily versus United States. Before Bourjaily, there was something called the bootstrapping rule. The idea was that the government couldn't use the very hearsay statement it wanted to admit as proof of a conspiracy. They had to come in with independent evidence, prove the conspiracy, and then the statement could come in. The Supreme Court changed all of that. In Bourjaily, the court said that when a judge is deciding whether to let co-conspirator statements in, the judge can look at the statement itself, along with other evidence, to decide whether conspiracy existed and whether the defendant was part of it. The court also said that the government has to prove these preliminary facts by a preponderance of the evidence, meaning more likely than not. That's a much lower bar than beyond a reasonable doubt, which is the standard that applies at an actual trial. So think about what that means in practice. The government can use the statements it wants to get admitted as a part of the basis for getting those statements admitted. Let me be direct with you about why co-conspirator hearsay is so dangerous if you're the one facing charges. Cross-examination is supposed to be the defense's primary tool. When a witness takes the stand, I can challenge their memory, expose inconsistencies, show bias, and reveal whether they have a motive to lie. With co-conspirator hearsay, I can't do any of that. The jury hears what someone said, and the person who said it is not sitting in the witness chair. On top of that, recorded statements carry a lot of weight with juries. When jurors hear an actual phone call where someone is discussing a drug deal and mentions the defendant's name, the impact is powerful. Even if the context is ambiguous, even if the defendant's actual involvement is unclear from the conversation. And in a large drug conspiracy case, the government may have hundreds of recorded calls between various co-conspirators. Even calls that my client was never a part of can be played for the jury as long as the court finds they meet the requirements of Rule 801 D2E. A defendant can end up facing a mountain of evidence from conversations they never participated in between people they may not even know. So what can you do about it? There are real defense strategies here, and a good defense lawyer will attack co-conspirator hearsay statements from multiple angles. The first thing I look at is whether the conspiracy actually existed. Prosecutors sometimes overreach. They'll characterize what was really just a buyer-seller relationship where one person simply purchased drugs from another as a full-blown conspiracy. A buyer-seller relationship is not the same thing as a conspiracy. If there's no conspiracy, these statements don't come in. Second, even if a conspiracy existed, I challenge whether my client was actually a part of the conspiracy. Being around people who were involved in drug activity is not enough. Knowing that illegal activity is happening is not enough. The government has to prove my client agreed to participate. If they can't, the co-conspirator statements are inadmissible against my client. Third, I scrutinize every single statement the government wants to introduce and challenge whether it was truly made in the furtherance of a conspiracy. Bragging, casual conversation, and statements made after the conspiracy ended, those don't qualify, and I fight to keep them out. Fourth, and this is a big one in wiretap cases, I challenge whether the wiretap itself was lawfully obtained. Federal agents have to get authorization under Title III of the Wiretap Act. They have to show probable cause, they have to demonstrate that normal investigative techniques weren't sufficient, and they have to follow minimization procedures to avoid recording conversations that are not relevant. If there are defects in the wiretap authorization, or if agents didn't follow these rules, I can file a motion to suppress everything that came from the wiretap. And if the wiretap evidence gets thrown out, the government's case will fall apart. Finally, I look at the Sixth Amendment's Confrontation Clause, which gives every defendant the right to confront witnesses against them. Now, in 2004, the Supreme Court decided Crawford versus Washington, which drew a line between testimonial and non-testimonial statements. If a statement is testimonial, meaning the speaker would reasonably expect it to be used in a prosecution, the Sixth Amendment bars its admission unless the defendant had a prior opportunity to cross-examine them. But here's the problem. The Supreme Court in Crawford specifically identified co-conspirator statements made in furtherance of a conspiracy as non-testimonial. Every federal circuit, including the Fifth Circuit in United States versus Crespo-Hernandez, has agreed. The reasoning is simple. When a co-conspirator is on the phone talking about a drug deal, he does not know the phone is tapped. He is not making a formal statement to the government. Because he does not know he is creating evidence, the government can say Crawford does not apply. That means the Confrontation Clause alone is not going to keep these statements out, which makes other defense strategies I described even more critical. However, if a co-conspirator made statements directly to a known law enforcement agent or during a formal proffer session, there is a strong argument those statements are testimonial and the Confrontation Clause does apply, which would bar their admission. If you're facing federal drug conspiracy charges, or if you think you might be under investigation, let me give you the most important piece of advice I can. Do not talk to anyone about your case other than your attorney. Do not discuss it on the phone. Do not discuss it in text messages. And especially do not discuss it on jail calls, because those calls are recorded and the prosecutor will use them. Here's why this matters in the context of what we're talking about. Anything you say could become co-conspirator hearsay evidence against someone else in the alleged conspiracy, and what they say can become evidence against you. The more people talk, the more evidence the government collects. Federal drug conspiracy investigations often go on for months or even years before charges are ever filed. The government is building its case the entire time. Getting a defense attorney involved early, before charges are filed, during the investigation phase, can make a real difference in the outcome. So that's co-conspirator hearsay, how it works, why it's so powerful, and how to fight it. If you or someone you know is dealing with a federal drug conspiracy charge here in Dallas or anywhere else in Texas or in the United States, give me a call right now, 214-526-1900. I offer free consultations. The sooner you get an attorney involved, the better your chances are of defending these cases.